Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 70. The first of our three cases this week considers a final written warning given by an employer allegedly in bad faith, and whether that warning could be relied upon for the purpose of determining the fairness of the dismissal for the employee for a later unrelated event. Secondly, we have a discrimination claim which the Court of Appeal have to consider whether the tribunal was wrong to exclude evidence that was of limited relevance. And thirdly, there's an EAT case that considers the increasingly relevant issue of costs awards. Key question that the EAT considers in this case is the relevance of a claimant's means when considering a costs award, and whether the tribunal is justified in awarding costs where the claimant is unable to pay. I'm then going to end. I've got some news on the timing of the next podcast episode. Do remember to check into the YouTube version of this podcast. It's quite a useful alternative way of accessing the podcast, particularly if you're doing so at work. In addition, it has got the names of the cases which appeared during the podcast. I also, if you remember, post links on my Twitter feed. And my Twitter account is Nicholas Robertson at Nicholas ROBER11, and that's got links directly through to all the cases that we discuss. Of course, we are in a relatively buoyant time for employment law, however employment lawyers are finding the market. We've talked about the manifesto, the three main parties' manifestos, insofar as they relate to employment matters. We also have, in addition to the regular flow of reported cases, this week we've had news that British Gas is appealing the Locke case. Apparently they discern there is a legal argument or arguments that they feel the tribunal didn't take into account. So clearly the holiday pay saga is going to rumble on and on. So all in all, there's a lot going on out there, and I think that's one of the benefits that certainly I find from doing the podcast series. It certainly helps filter and distill the thinking as to what matters and what's just noise. So, starting at the beginning, Way and Spectrum Property Care Limited. This is the Court of Appeal decision, and it looks at whether a final written warning allegedly given to an employee in bad faith could be relied upon for the purpose of supporting the employer's decision to dismiss the employee. I emphasise there has been no finding that the warning was given in bad faith, as for reasons I will explain, the tribunal had to make that assumption for the purpose of considering the legal arguments. In Mr. Way's case, he was given a 12-month final written warning in December 2010 for inappropriate recruitment activities because he failed to declare his interest in an applicant, contrary to Spectrum's procedures regarding fair recruitment and disclosure of relationships. The written warning stated that the conduct improvement expected of Mr. Way was for him to ensure that he was fully familiar with the group policies and procedures as detailed in the staff handbook, and these included Spectrum's computer usage policy. Less than 12 months later, following an organisation-wide investigation into inappropriate email usage, Mr. Way was found to have sent inappropriate emails judged to be in the red category. This was less serious than the gold category that warranted summary dismissal on grounds of gross misconduct, but more serious than amber, which only resulted in a letter of concern. The red category meant that Mr. Way was to receive a final written warning. However, as he was already subject to a live final written warning for the separate and unrelated offence I mentioned earlier, a disciplinary process was initiated and he was subsequently dismissed. This was in reliance on the earlier final written warning, and that point's important. In his appeal, Mr. Way raised what he alleged was the bad faith of that written warning, that earlier written warning, stating that his line manager had been involved in the recruitment process that breached Spectrum's policies, and the warning had been given to cover up that line manager's involvement. This appeal was dismissed, and this point in the appeal was dismissed after what appears to my eyes at least from the report, to have been a fairly thorough investigation by the appeal manager. Mr. Way brings a claim in the Employment Tribunal in which he argues that the final written warning, which Spectrum had relied upon in dismissing him, had been given in bad faith. And there then seems to be a bit of a procedural problem, because the appeal manager, through no fault of his own, was unable to give evidence at the tribunal hearing. But the tribunal and the claimant wanted the hearing to go ahead regardless. As a result of this procedural glitch, the tribunal refused to hear evidence about the background to the final warning. It concluded the dismissal had been fair in the light of Mr. Way's existing final warning. Mr. Way appeals to the AT, who declined to remit his case and so turned down his appeal. The AT ruling assumed the possibility that the final written warning was given in bad faith, but despite that, the AT considered the final written warning could be relied upon. Mr. Way appealed against the AT decision on the basis that the warning given in bad faith cannot be relied upon at all for the purpose of determining whether there is a sufficient reason to dismiss an employee. He relied upon the case of Wincanton Group plc and Stone, in which specific guidance was given to tribunals on the issue of earlier warnings and their relevance in a unfair dismissal claim. And that case confirmed, quote, "If a tribunal is not satisfied that the first warning was issued for an oblique motive, or was manifestly inappropriate, or, put another way, was not issued in good faith, nor with prima facie grounds for making it, then the earlier warning will be valid. If it is so satisfied, the earlier warning will not be valid, and cannot and should not be relied upon subsequently." Wincanton highlights that a warning for conduct may hold greater weight if the later conduct is of the same nature, and of course that wasn't the case here in Mr. Way's case. Mr. Way also relied on the case of Davis and Sandwell, which was discussed back in Mayor Brown podcast number 18, released back on 8th March 2013, long time back. And that case provides guidance on the correct approach to reliance by an employer of final written warnings, confirming, quote, "It is legitimate for an employer to rely on a final written warning, provided it was issued in good faith, and that there were at least prima facie grounds for imposing it, and it must not have been manifestly inappropriate to issue it," unquote. Well, the Court of Appeal aligned itself with these earlier authorities, stating that the AT's decision had a degree of illogicality about it, confirming that a warning given in bad faith is not, in circumstances such as Mr. Way's, to be taken into account in deciding whether there is sufficient reason for dismissal. The Court of Appeal held that an employer would not be acting reasonably in taking into account such a warning when deciding whether the conduct was a sufficient reason for dismissing him. Critically, the Court of Appeal dismissed the employer's argument that the manager who'd heard the appeal, and who had considered whether the earlier final warning had been given in bad faith, had acted reasonably, and therefore the dismissal was fair. The Court of Appeal said it was no defence to the claim that the earlier warning had been given in bad faith, to say that the manager who dismissed the individual had been acting in good faith when rejecting that bad faith argument. In other words, a final written warning given in bad faith or for manifestly unreasonable grounds is treated as if it is struck off the record. In general terms, I think the Court of Appeal's decision covers ground which has been gone over before. The direction of travel is quite clear. It's quite common to find employees seeking to challenge the validity of a dismissal by looking back to an earlier stage in the disciplinary process. And the bar for these challenges is set fairly high, because the courts really don't want to permit satellite litigation. But this case does widen the door slightly for such challenges. In the past, I think it would have been at least arguable that the decision to dismiss is what is being challenged in front of the courts. And if the decision to dismiss was taken in good faith, and having considered the argument about the final written warning being given in bad faith, then the good faith of the dismissing manager should allow reliance on the final written warning. However, that's not what the Court of Appeal has said. A final written warning is effectively invalidated if it was given in bad faith or on manifestly unreasonable grounds. I think the best advice to give to an employer is where such an argument is raised during the internal disciplinary stage, i.e. at the dismissal hearing or the appeal against dismissal hearing, the employer needs to go into this in as much detail as possible before coming to its view. Sadly, the Court of Appeal's decision means that merely taking every due care to come to a view about the earlier final written warning is not automatically a defence, but in the real world it's surely likely to lead to a greater chance the court will reject the allegation that the final written warning had been given in bad faith. So that's the case of Way and Spectrum Property Care Limited. The next case is Carlu and Brighton and Sussex University Hospitals and others. This is another Court of Appeal decision, in fact, and this looks at a race discrimination claim following a proposed policy that allegedly favoured white consultants. The issue that the Court of Appeal had to consider was whether the tribunal had been justified in excluding evidence considered to be of limited relevance to the issues in the particular case. The Employment Tribunal procedure is governed by the Employment Tribunal Rules of Procedure, which in turn is set out in the Employment Tribunal Regulations 2004. This confirms the overriding objectives, which ensure that employment tribunals and judges deal with cases justly. Objectives include ensuring the parties are on an equal footing, dealing with cases in ways that are proportionate to the complexity or importance of the issues, ensuring the case is dealt with expeditiously and fairly, and saving expense. Obviously, it's not unknown for claimants to bring in significant amounts of evidence of questionable relevance. In the case of HSBC Asia Holdings and others against Gillespie, and the case of Digby and East Cambridgeshire District Council, the EAT has provided guidelines for tribunals to consider when exercising their power to exclude evidence on the grounds that it is insufficiently relevant. The cases confirm that a tribunal has, quote, a discretion, in accordance with the overriding objective, to exclude relevant evidence which is unnecessarily repetitive, or with only marginal relevance in the interests of proper modern-day case management, unquote. Well, in this case, Mr. Carlew and the appellant hospital trust consultants worked in obstetrics and gynecology. The trust ran 2 hospitals, and Mr. Carlew, who is black, worked in the Haywards Heath Hospital with 4 other consultants, 3 of whom were black, Asian and minority ethnic, BAME, backgrounds. Their counterparts in the second hospital in Brighton were largely white. The Trust proposed a policy to manage the 2 obstetrics and gynecology departments in the event of a swine flu pandemic, and that in effect resulted in the BAME consultants losing their registrar to the white consultants at Brighton. Mr. Carlew brought claims of direct racial discrimination and victimisation against the Trust and 4 consultants working at Brighton as a result. He named the white consultants as comparators. After raising his objections, the Trust never implemented the policy, but obviously the litigation was underway. 4 working days before the Employment Tribunal hearing, Mr. Carlew sought to bring in witness statements and documents pertaining to historic race discrimination claims that he brought against the Trust, and which had been previously settled. The Trust applied to the Tribunal to have the parts of his witness statement that related to the past discrimination claims removed on the grounds that these had been settled and were just not relevant to the case. The Employment Tribunal dismissed Mr. Carlew's claims for reasons of by reason of the 2 hospitals having different features, and these were significant and material to the policy, and the policy, it said, had not been formed on a discriminatory basis. It had also agreed, the Tribunal, to exercise its powers of discretion to exclude the irrelevant sections of Mr. Carlew's witness statement. Mr. Carlew appealed. One of his grounds of appeal was that the Tribunal prevented him from entering into evidence the relevant background material to demonstrate the preconceived alleged hostility towards him by the Trust and comparator consultants on racial grounds. Mr. Carlew argued that the Tribunal's ruling in this case was contrary to well-established authorities and principles at EAT and Court of Appeal level, such as ANYA and University of Oxford, in which it was accepted that a respondent's prior acts might be highly relevant. Well, the EAT agreed with the approach taken in ANYA, concluding that the evidence excluded by the Tribunal had been relevant and should have been admitted into evidence. And the case goes to the Court of Appeal. So what happens? Well, Court of Appeal overturned the EAT, agree with the Employment Tribunal and the guidelines set out in HSBC and Gillespie, supporting evidence which is insufficiently relevant and acts as a distraction should not be allowed into the hearing. Indeed, and interestingly, Court of Appeal held it could be oppressive, their term, to use it. In these circumstances, the Court of Appeal held that what had been excluded was not the evidence that there was a history of claims against the Trust, but instead the details of those claims. The Court of Appeal concluded that such information did not provide support for the current allegations, but related to claims from 2 years before, which consisted of alleged discrimination that was of a different nature to the current claim. The Court of Appeal stressed the need for a party to give notice of its intention to raise such evidence so that the other party is on notice, and also to bear in mind the overriding objectives as, in this case, to admit this additional evidence would have resulted in disproportionate cost and delay. The Court of Appeal concluded the Tribunal had directed itself properly, and its assessment of excluded evidence was relevant to the proportionality of cost, delay, and reopening matters of past history that were not directly in support of the current allegations. So I think overall this case is a good one. It's a useful one for employers. It provides helpful confirmation of the guidelines in the HSBC case and the Tribunal's ability to limit the evidence that a claimant wants to bring in. Tribunals have historically been reluctant to limit evidence for the fear that the evidence that is being excluded is relevant and it may somehow open up the grounds for an appeal. And As I say, claimants often try to adduce as much evidence as they possibly can, as doing so doesn't really impact their costs, and there are currently no constraints on the amount of evidence that a claimant can admit in support of their claim. Although the case was fact-specific and other circumstances allowed the tribunal to exclude the evidence in this case, it is helpful to see the Court of Appeal agreeing with the tribunal's decision to exclude evidence of limited relevance and confirming the guidelines given in the HSBC and Gillespie case. Trying to focus on the real issues in a hearing is one of the key battlegrounds in the run-up to that hearing, both in terms of ensuring that the tribunal comes to the right decision because it has the right material in front of it and is able to see the wood from the trees, but also it keeps the costs down to an appropriate level. So that's the case of Carlew and Brighton and Sussex University Hospitals. Third, final case, Chadburn and Doncaster and Bassett Law Hospital, NHS Foundation Trust and another. This is an EAT case, not a Court of Appeal case. It's an EAT case which considers the tribunal's decision to award costs against the claimant who'd been unsuccessful in her claims of race discrimination. The costs were awarded despite her barrister describing her finances as being in, quote, dire straits, unquote, and the tribunal stating that the, quote, award was made in the full appreciation that the claimant could not currently afford to pay anything at all, unquote. To give some legal background, tribunals have a broad discretion under the Employment Tribunal Regulations 2013 to award costs when, in the tribunal's opinion, a party or that party's representative has acted vexatiously, abusively, disruptively, or otherwise unreasonably in either the bringing of the proceedings or part, or the way that the proceedings or part have been conducted, unquote. The cap on this award is £20,000 unless the costs application is made to the tribunal, where costs can be determined on a detailed assessment, and the award can then be increased beyond £20,000. When making a costs award, the tribunal may have regard to the paying party's ability to pay, but it is not obliged to do so. The case of Vaughan and London Borough of Lewisham established it's not necessary for the tribunal to set the award amount to be an amount that the paying party is able to pay at the time of the award, or even within a specific period following the award. Instead, the tribunal should consider whether, quote, there is a realistic prospect that the party might at some point in the future be able to afford to pay, unquote. In this case, the claimant, Mrs. Chadburn, brought tribunal claims for unfair dismissal and race discrimination, and the tribunal dismissed all of Mrs. Chadburn's race discrimination claims, holding that these had been invented so that she is able to bring her harassment claims within the tribunal's jurisdiction. Consequently, the tribunal concluded that she had acted unreasonably within the Employment Tribunal Regulations definition in bringing the proceedings, as her actions had resulted in approximately £35,000 of additional legal costs for the Trust, and as such, it had decided to award costs of £10,000 against Mrs. Chadburn. Mrs. Chadburn, of course, appealed the decision. Before the case reached the EAT, it was stayed to allow the tribunal to reconsider its cost judgment on the basis that Mrs. Chadburn submitted additional evidence in the appeal tribunal bundle that had not been put before the Employment Tribunal. The core point raised in the additional information was that Mrs. Chadburn's debts were worse than had been originally depicted to the tribunal. The Employment Tribunal accepted that the financial position advanced by Mrs. Chadburn was worse than had previously been recognised, but ultimately concluded that there was no reasonable prospect of the tribunal varying or revoking its cost decision, even in the light of this new information. The tribunal found that, given Mrs. Chadburn's age, I think she was 39, and the potential to obtain future employment, she might at some point in the remainder of her working life be able to afford to pay an award of this size. Mrs. Chadburn appealed the cost decision on two grounds. First was that the tribunal took into account her pending divorce proceedings and any financial provisions that may be made for her in any divorce settlement. Mrs. Chadburn contended this was speculative, particularly given there was no evidence as to her husband's means, and the marriage was short and childless. Secondly, Mrs. Chadburn argued that the tribunal had failed to consider the true extent of her debt, which was in the region of something like £4,300 and wasn't £600. The EAT rejected her appeal, concluding the Employment Tribunal had taken the correct approach in its consideration of her means and its decision to make a costs award. In respect to Mrs. Chadburn's argument that the tribunal had wrongly taken into account the fact that her financial position may improve following her divorce, the EAT held this was not the principal matter the tribunal had relied upon. Instead, the tribunal had focused its decision to award costs against her on the basis that she was only 39, had plenty of working years left ahead of her. The tribunal had only identified the possibility that future divorce proceedings might impact positively upon her financial position, and this was, quote, not the only basis, nor even an equally important basis, upon which the tribunal's reasoning and ultimate conclusion was, or could be justified, unquote. The EAT held that there was no positive evidence to the effect that Mrs. Chadburn had no realistic prospects of obtaining employment in the future, or of improving her financial position as a consequence, and therefore the tribunal was entitled to reach its conclusion, irrespective of its consideration of the impact of her pending divorce proceedings on her future financial position. As to the failure to accurately consider her true debt, the EAT held that the tribunal is not obliged to consider a party's ability to pay when deciding the amount of costs ordered, or whether that sum can be paid at the time of the order, or even within a specified time period. The tribunal needed to consider whether there was a reasonable prospect that the party might at some point in the future be able to afford to pay. The EAT agreed with the approach taken in Vaughan, that the question of affordability need not be decided once and for all by reference to a party's means, as at the time the award is made. The EAT recognised that affordability is not the only criterion for exercise of discretion, and the EAT rules do not require a precise estimate of what can be afforded, and here the tribunal hadn't made any such estimate. It only decided that a detailed assessment of a sum greater than £20,000 was not realistic in the circumstances, but that a summary assessment of part of the costs was appropriate. The EAT's decision also notes the award was less than one-third of the trust's costs incurred in defending, quote, vexatious and false allegations she knew to be untrue, which had the effect of doubling the length of the hearing, significantly expanding the issues and involving witnesses who would otherwise not have needed to be involved in the tribunal proceedings at all, unquote. Apart from that, they were right on board with her, I think. Anyway, to put this into some sort of context, in 2013-14, there were 889 costs awards made by employment tribunals, median award of £1,000, top award of £58,022. Costs awards are becoming increasingly more relevant. This statistic is up from 651 costs awards the year before. The figures are possibly indicative, well, I think more than possibly, probably indicative of a change of approach to costs awards taken by employment tribunals. These cases, and this case indeed, is likely to have an impact on low-means litigants who are currently not deterred by the tribunal fees from bringing a claim, and more specifically, cases in which a claimant acts unreasonably or is seeking to make false allegations in furtherance of the tribunal litigation. The statistics for 2014-15 have not yet been published by the employment tribunals, but when they are, it'll be interesting to see if this trend continues, particularly bearing in mind the continued low level of numbers of employment tribunal cases being started in England and Wales. It does seem to me that employment tribunals are becoming markedly less reluctant to award costs against parties. So, that's the case of Chadbourne and Doncaster and Bassett Law Hospital. And indeed, that's it for another podcast. Thank you very much for listening. I said I'd mention something about the timing for the next podcast. The next podcast is going to be a few days late. I'm away next week on holiday, part of which is spent watching my wife do the Caledonian Etap. Needless to say, my wife was horrified to discover that it still snows in Pitlochry in May. So that sounds like it's going to be a bit of a hardship. Not my idea of fun, anyway. Anyway, I'm then away the following week, which will be the podcast week, because I'm attending a business management course at Harvard, which should be interesting. Accordingly, podcast is going to come out at the start of the following week, i.e. 2 and a bit weeks later from the date of recording this podcast. I hope that will not be too inconvenient. And by way of an apology, I posted on my Twitter feed a link to my current favourite Twitter topic called, quote, "You only had one job," unquote. The image concerned is marvellous, and there's a whole series of hilarious images of things that people have managed to mess up, which really should not be capable of being messed up. So, leave you with that, and I'll be back in 2 and a bit weeks' time. Take care.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.